Right. There's the three of you. Your mother, Julie, and Mark, and Andrew, died intestate. And very sadly, what that means is that it's unclear as to the intentions of how she intended to give out all of her money. So what happens in those circumstances is the court implies, rightly, that all of the surviving immediate family are entitled to a share equally. You were only aware, Julie and Mark, of £3,000 or thereabouts. Now, I'm satisfied, having considered the papers, and I am satisfied about this, Andrew, that that money, all of that policy, and some more, including the £400, which they didn't know about, has been used up in the funeral expenses. So I don't take that into consideration. What they weren't aware of was a £2,000 ISA, which represented a significant portion, almost half, of your mother's life savings, which until they pushed and they pulled and they attempted to find out more about what your mother left, they weren't aware of until this very day. You were under a specific duty to tell them about it. Why? Because you knew full well, and I'm satisfied you did, that they were entitled to their equal share of that. Now, I hear what you say, Julie. You're only coming to court today for £500 to lay your mum finally to rest.
That's right.
And I hope the three of you can come to an agreement about that, just as you have about the funeral expenses. But I'm not satisfied, very unusually, that your claim is sufficient. Because in my determination, based upon what I've heard, you're entitled to rather more than that. You're entitled to your 2/3 share, which I determined was the intention and the correct and equitable, in other words, the justice of this case. So the award of this court is 2/3 of the rest of your mother's estate, and the award to you both to share is £1,333.33. Now, money can't cure anything. Go outside and talk to each other and listen to each other. You saw the picture of what life was like beforehand. It's a pretty cheap reason for a family to break down. The award to you, £1,333.33.